As some of you know, that in the last 2 weeks, we have been bombarded by people that decided that they want to come to the conference because all of a sudden the issue became, the issue of the digital platforms became very topical, not to say hot. But I have to be honest and admit that one of the first people who agreed to come and talk today actually did it way before it was topical, and I really want to thank him for that. And this is our next speaker. So Makan Delrahim is the Assistant Attorney General for the Antitrust Division at the Department of Justice. He previously served as Deputy Assistant to the President and Deputy White House Counsel. He has a rich background in antitrust, both as counsel and enforcer. He's a former partner in the Los Angeles office of a national law firm, and between 2003 and 2005, he served as Deputy Assistant Attorney General overseeing the Appellate International and Legal Policy sections. He has served on the Attorney General's Task Force on Intellectual Property as chairman of the merger working group with the International Competition Network. Mr. Delrahim was also a commissioner on the Antitrust Modernization Commission from 2004 to 2007. Earlier in his career, Mr. Delrahim served as an antitrust counsel and later as the staff director and chief counsel of the U.S. Senate Judiciary Committee. I have to tell you that I had the opportunity in the last 10 minutes. I was privileged to see Mr. Delrahim speech, and it's going to be quite powerful. And I really thank him for choosing this venue to bring this message. Mr. Delrahim.
Thank you so much, guys. Appreciate it. Thank you so much. It's a great honor for me to be here amongst you, to join such an impressive group of legal academics, economists, practitioners, and others here in the Windy City. I'm honored to provide the luncheon keynote sandwiched between my friend and former AMC colleague, Dennis Carlton, whom you heard from this morning, and also my friend, Professor Carl Shapiro, whom you will hear from this afternoon. It seems of late that I have a tendency to divide these two great economists. I hope today, at least, we'll have consensus, although I would have far preferred for that consensus to have occurred last week in the courtroom. It's also a great and a real honor to see my friend, former Prime Minister of Italy and former European Commissioner for Competition, Mario Monti, who is certainly a pioneer on the issues of the economic aspects of competition from his service on the Commission, amongst others. And it's great and a great surprise to see Professor Alvin Roth, who honored us at the Justice Department in being the inaugural speaker of the Jackson Nash lecture that he provided to us just a couple of months ago, in January, I think. Time has been going by fast. For me, it feels like I'm standing on hallowed ground here at the University of Chicago, where some of the world's leading antitrust scholars have played a crucial role in developing modern doctrine. Ed Levy, Aaron Director, Robert Bork, who was mentored here by Aaron Director, just name a few names: Easterbrook, Posner, DOJ alumnus Diane Wood, Landis, Epstein, just to name a few. At the Justice Department now, we have numerous grads of this excellent institution, including my principal deputy, Andrew Finch, and deputy for litigation, Don Kempf, who's a graduate of the business school here, and of course, the United States Solicitor General Noel Francisco. Our chief economist, Luke Frobe, was a Kramer Fellow here, and we have many others at the Justice Department. This university's contributions have helped set the groundwork for the broad antitrust consensus that still reigns today, and I personally thank you and congratulate you for the contributions to our field of law and economics. I'm pleased to talk today about this antitrust consensus and what it means for the digital world. The antitrust consensus, in my view, has two key components. The first component is a consumer welfare standard, which condemns practices as unlawful where they harm competition in such a way that consumers suffer. The consumer welfare standard is the lodestar of antitrust enforcement and a humble recognition that antitrust law, if misapplied, can have harmful consequences for those it intends to protect. The second component, which is the focus of my remarks today, is what I and others call evidence-based enforcement. An evidence-based approach requires enforcement built on credible evidence that a practice harms competition and the American consumer, or in the case of merger enforcement, that it creates an unacceptable risk of doing so. Outside the realm of naked horizontal restraints such as price fixing, bid rigging, and market allocation, antitrust demands evidence of harm or likely harm to competition, often weighed against efficiencies or pro-competitive justifications. As enforcers, we exercise our prosecutorial role every day using this approach to review economic evidence to determine whether a restraint or on its face violates the antitrust laws. Taking an evidence-based approach to antitrust law should not be mistaken for an unwillingness to bring enforcement actions. In fact, where there is clear evidence of harm to competition, it is the duty of enforcers to promptly and vigorously prosecute the antitrust laws and to refuse to settle for ineffective behavioral band-aids that fall short of curing the underlying threat to competition and consumers. Believe me, it's a lot easier to accept some pretty promise, issue a press release congratulating ourselves, and move on to the next matter. Convenience, however, is not in the oath we take to uphold the U.S. antitrust laws. Evidence-based enforcement also requires a readiness to adapt our existing antitrust framework and tools to new and emerging threats. It's an approach of openness to persuasion and is adaptable to new business models and emerging technologies that create novel threats to competition and consumer welfare. This brings me to the two topics of this conference: digital platforms and concentration. I'm aware that some in the audience believe that existing antitrust laws are ill-equipped to address competition issues that have arisen in the digital platform economy, and that as a result of the antitrust law's supposed lack of adaptability, there have been harmful increases in industry concentration, along with a variety of other social ills. Some lay the blame for this state of affairs at the feet of the consumer welfare standard itself. Others blame antitrust enforcers for falling short of taking action against companies or transactions that might harm competition. Enforcers do indeed deserve some blame, particularly for their willingness to settle for ineffective regulatory fixes to mergers rather than challenging them when necessary. Yet overall, I have reason for optimism. Based on my collective experiences for the past 25 years, I believe the antitrust consensus approach is flexible to new business models in digital markets, and that there's no persuasive evidence that antitrust itself has failed. The antitrust consensus may fall short if enforcement agencies are unwilling to take action based on credible evidence, or even worse, imposing fixes that transform law enforcement agencies into inefficient regulators, where the free markets can do a more effective and more honest job. Over the past several decades, antitrust law has responded to new and innovative products and markets to protect against novel threats to the competitive process. Enforcement agencies have developed a strong expertise as new types of assets emerge and consumer preferences shift, and have brought successful antitrust challenges to dismantle barriers to competition. The landmark United States versus Microsoft case is illustrative. The Antitrust Division's theory of harm in that case may have been cutting edge, yet the framework that the en banc DC Circuit applied did not mark a seismic shift in how we think about antitrust law. The Court of Appeals noted that, quote, there is no consensus among commentators on the question of whether and to what extent current monopolization doctrine should be amended to account for competition in technologically dynamic markets characterized by network effects, close quote. That was in 2001, and it rings true today. Rather than, quote, amending antitrust doctrine, the court applied established principles of market definition and monopolization under the Sherman Act to a product for which there was little agency or judicial experience. The Microsoft case came at a pivotal moment in the expansion of technology and digital networks. Prime Minister Monti certainly knows that well from his experience at the time on the European Commission. We were on the brink of the internet revolution with the launch of an efficient web browser developed by Mark Andreessen and his then startup Netscape. The Microsoft case proved that an evidence-based antitrust enforcement approach can be flexible in its application to new types of assets and markets. In that case, the computer code and software markets. As enforcers, each day we confront similar challenges in adapting our antitrust tools to new business models. With each new challenging market or transaction, novel but tested economic modeling is necessary. We rely heavily on the work of economists deploying the most sophisticated economic techniques. Yet some ask, how can we stay at the forefront of technological change so that we can protect competition before it's too late? A basic concept in economics that is helpful in the new area of high-tech platforms is the theory of revealed preference. It's a seemingly straightforward concept. Individuals' choices, including what they decide to purchase or forego, indicate their preferences. We can infer the relative values consumers place on alternatives by how they behave, that is, based on what they purchase, what they sell, and how they make the trade-offs. The late Nobel laureate economist Paul Samuelson, who was principally responsible for the revealed preference theory, described it as follows, I quote, by comparing the costs of different combination of goods at different relative price situations, we can infer whether a given batch of goods is preferred to another batch. The individual guinea pig, by his market behavior, reveals his preference pattern, if there is such a pattern. This concept is particularly helpful in understanding dynamic or emerging markets, including the digital markets. That is, economic value is demonstrated by the consumer's willingness to pay for goods and the services. With recent congressional attention and rising consumer awareness, we may be witnessing a revealed preference for personal data privacy in the digital economy. 10 years ago, few of us may have cared whether companies had access to our data. We would give up our private, personal data freely in exchange for access to a, quote, free platform to connect to friends or to total strangers. But the public now recognizes that for many such platforms, advertisers on the other side of the platform pay handsomely for that access. Indeed, Franklin Foer characterizes data as the new oil. He writes, and I quote, it's the record of our actions, what we read, what we watch, where we travel over the course of a day, what we purchase, our correspondence, our search inquiries, the thoughts we begin to type and then delete, close quote. Eric Schmidt, in 2010, when he was the CEO of Google, put a finer point on it, saying, quote, we know who you are. We know where you've been. We can more or less know what you're thinking about, close quote. Of course, a year earlier, Schmidt offered that, quote, if you have something that you don't want anyone to know, maybe you shouldn't be doing it in the first place. With a greater understanding of the nature and scope of data collection and sharing today, the mentality regarding free platforms may well be changing. I know that for me, it has changed. How many of you would pay $1 a year so that your social media data would never be shared with a third party? $12 a year? $100? Your answer is likely different than what it was in 2008 and what it may be in 2028. And not everyone's answer is the same. Like any good or service, there's a trade-off between what you give up in exchange for what you obtain. That trade-off may be different across the population. From an economic standpoint, the key takeaway is that revealed preference for data privacy could signal the emergence of a new market asset. Indeed, in recent weeks, we have witnessed the attention paid to the role of consumer data aggregated by digital platforms and how this data might be used or misused by companies that collect it. Of course, for sophisticated followers of these business models, none of this is surprising. Going back at least 10 years, political campaigns have relied on social media data to hone their messaging and voter outreach efforts. Lest we forget, it was not that long ago that we were heralding the role of social media, particularly Twitter, as a potent force of political messaging and voter outreach to challenge authoritarian rule throughout much of the Middle East, including in my birth country of Iran. We may now be witnessing a fundamental change in the marketplace. As preferences shift, or as users of digital platforms become better informed about the consequences of sharing their private data, we could be entering a world in which a substantial number of consumers view their data as an asset they won't part with for free. At a basic level, the bargain between platform and the user appears to be shifting. And at the margins, and with a generational shift, some may opt out of certain networks because they simply don't see the bargain as working in their favor. Time will tell. As a result, the overwhelming incentives to design technologies to maximize the collection and use of personal information may also be shifting. And with that shift, companies are designing technologies that respond to our revealed preferences for privacy. Some call it, quote, privacy by design. But in essence, it's a simple idea that companies can respond to changing demands by designing and marketing technologies with privacy as the default setting. There's some evidence to support the idea of this emerging market for data privacy. Users of online platforms now are exercising greater control of their data through modifications to their security and privacy settings. News reports also suggest that many users are tuning out social media networks that they believe to not provide adequate protection of their personal data. And new services are emerging that respond to the changing preferences. Indeed, Facebook Chief Operating Officer Sheryl Sandberg has floated the idea that customers would need to pay a premium price for total privacy. And the popularity of Snapchat, which posed some competitive threat to Facebook, was largely based on its so-called, quote, vanishing chats. In other markets, we already have examples of consumers making choices that favor privacy. Music streaming services like Pandora and Spotify, for example, have basic subscriptions with ads and premium subscriptions without it. What role does antitrust play in all this? In the current environment, there's an arms race among some enforcers to use the strongest remedies available to combat the perceived problem. Reminding us of the H.L. Mencken quote, that quote, there's always a well-known solution to every human problem that is neat, plausible, and wrong. For example, some argue that U.S. or international agencies should simply declare that data is the new digital currency, that online platforms have been exploiting data without consent, that loss of informational control is anti-competitive, and then impose eye-popping penalties by multiplying some measure of data value by the size of the customer base. I wouldn't call that and antitrust remedies stemming from an evidence-based analysis. Such an approach ignores the economic nuance of revealed preference. Money has face value, but privacy cannot yet be measured in nominal terms and varies according to the type and utility of the data used. A more effective approach, grounded in evidence, would be to ensure that there are sufficient incentives for new competitive entry in markets for platforms with network effects, while ensuring that customers who prefer established business models still have access to the product or service they want. Many experts have testified that imposing rigid regulations or a new and likely irreversible statutory scheme may not be a necessary or a viable solution for fostering competition. Like other government entities, competition authorities and consumer protection agencies are at risk of regulatory capture. There's a long history of incumbent companies manipulating regulatory schemes to create entry barriers. A monopolist may be willing to incur a cost for maintaining its monopoly if the same cost is applied to new competitors. In that event, consumers don't win. That's not to say that antitrust law and economics should play no role, quite the opposite. When any new asset class emerges, companies will try to gain monopoly power over that asset. This can cut two different ways. On one hand, in certain platform markets involving network effects, there may be barriers to entry or a tendency toward a single firm emerging as the sole winner. Antitrust enforcers may need to take a close look to see whether competition is suffering and consumers are losing out on new innovations as a result of misdeeds by a monopoly incumbent. On the other hand, of course, antitrust economists understand that monopolies often can be fragile and they give rise to new entry. Indeed, it is the prospect of gaining lawful monopoly power that provides incentives to innovate and create products consumers want. We seek to encourage competition for the market, that is, dynamic competition to innovate and provide new products or services that customers demand. In reaction to controversies over how companies use or misuse personal data, we may see the emergence of new competitors in this digital space that attract customers based on promises of user privacy. Neither antitrust agencies nor incumbent monopolies should be allowed to kill off this type of competition. Antitrust enforcement should ensure that the markets allow for new, more efficient, more innovative competitors to enter. Whether antitrust enforcement makes sense in this area is therefore an evidence-based question. Are consumers who believe that their data is digital currency facing a monopoly seller or a monopsony buyer with structural barriers to competition and entry? This is the question enforcers should answer. Admittedly, it's a complex question, and we need studies and new innovative thinking, exactly the kind of thinking that occurs and is fostered at institutions such as the University of Chicago. The Antitrust Consensus approach is flexible enough to accommodate new and evolving economic wisdom, so long as it is grounded in empirical evidence. If there's an evidentiary basis for enforcement action against any platform, and if that enforcement action is built on sound economic foundation, antitrust agencies should fulfill their duties to the American consumer. Even though economic analysis can adjust to evolving business models, there are still criticisms that existing antitrust doctrines are ill-equipped to handle more nuanced threats to competition that may exist in the digital markets. Some scholars have taken aim at predatory pricing doctrine in particular, which in their view condones below-cost pricing models that sweep away competitors and raise the prospect of future price increases. It's worth recounting exactly why predatory pricing claims, in particular, face such a high bar. The Supreme Court in Brook Group recognized the serious danger of condemning business practices that are pro-consumer. Indeed, a predatory pricing claim is the most dangerous tool in an enforcer's toolbox because it seemingly would condemn the type of action that is at the heart of competition, charging a lower price than one's competitor. As the court explained, quote, "It would be ironic indeed if the standards for predatory pricing were so low that antitrust suits themselves became a tool for keeping prices high, end quote. The court therefore required a showing of a, quote, dangerous probability of recoupment, as well as pricing below an appropriate measure of its rivals' costs. Some view this test as exceedingly difficult to meet, but that is precisely the point of the doctrine. The fact that predatory pricing claims frequently fall short does not mean the doctrine itself is inadequate. It means it might well be working. At the same time, I believe that as enforcers, we should be open and receptive to empirical evidence that companies in digital markets may be engaging in predatory pricing or other exclusionary conduct to drive out competition and cause long-run harm to the consumer. I am encouraged by the fact that theoretical work has recently emerged on this front. For example, as a Yale law student, Lena Kahn wrote an interesting student note in the Yale Law Journal that has drawn significant attention to how predatory pricing or other exclusionary conduct claims might apply to digital platforms. Her note has been subject to some criticism, but we should encourage fresh thinking like this on how our legal tools apply to new digital platforms. We need more thinking, diverse thinking about these questions, and we need a civil discourse on this topic. Contrary to what some critics suggest, however, I believe the antitrust consensus itself need not be discarded in order for a predatory pricing claim to be successful. What we need is a sound body of evidence that dynamic competition will be harmed, such that consumers will suffer in the long run by the practices that we are concerned about. In the context of digital platforms, an evidence-based approach is critical to protecting innovation. Disruptive competition and new business models are healthy, and they should be encouraged. It is rational, pro-competitive, and pro-consumer for new entrants to charge low prices. Predation that harms competition, however, should not be condoned. Another approach to exclusionary conduct in the digital markets that might be worthy of consideration is the economic sense test within the Brook Group framework. That is, there may be an antitrust violation where a business practice makes no economic sense other than to harm competition and subsequently recoup the short-term losses. Enforcers should be receptive to new thinking in this area, and I encourage experts in academia, private practice, and the public policy sphere to rise to the occasion and enlighten us. It would be particularly helpful for the bar and the academy to ask how the current analytical tools can address emerging challenges of digital platforms based on the existing jurisprudence. Just as the Department of Justice, the European Union, and the DC Circuit addressed the then emerging issue in the Microsoft case, the antitrust laws are flexible enough to address competition issues from emerging platforms. As enforcers who bear the burden of proof, we must demand hard evidence of anti-competitive harm before rushing to condemn as unlawful business practices that fuel innovation and dynamic competition. An evidence-based approach to antitrust law also should be self-reflective in order to assess the real-world results of the antitrust consensus. In this regard, critics of the consumer welfare standard have their hearts in the right place. Yet critics of the current regime may be forgetting to subject their preferred approach to a hard, evidence-based evaluation of its own. I refer specifically to the claims that industry concentration has dramatically increased with the antitrust consensus as its primary culprit. Many of these critiques date back to a 2016 quote issue brief issued by the Council of Economic Advisors asserting evidence of a quote decline of competition and increased industry concentration. Academics, commentators, and journalists made similar claims in subsequent months. As a side note, my favorite has to be the John Oliver segment on concentration that aired on the HBO network this past fall. For anybody new to antitrust, which is nobody in this room, I commend that clip. Most of the concentration claims rely on data from the US Census Bureau, yet those data are overly broad aggregations of economic activity. The concentration of an industry is not the same thing as the concentration of an antitrust market. No available data demonstrates increasing concentration of markets as economists and antitrust enforcers define them. My point is consistent with a similar point made by Professor Shapiro, also alumnus of the Antitrust Division and a member of the Council of Economic Advisors, a few years before the issue brief was released. In a forthcoming article, he explains why the evidence on concentration cited by the CEA is not informative regarding the state of competition. A future explanation of why that is so has just been posted by the Social Science Research Network by the Antitrust Division's economists Greg Worden and Luke Frobe. If one compares the commerce of relevant markets to the commerce in corresponding industries, one can readily recognize the discrepancy. For 32 of the 44 relevant markets examined for mergers filed between 2013 and 2015, the least aggregated census industry measure was more than 100 times broader than the relevant antitrust market. The excessive aggregation of census data makes them uninformative on trends in market concentration. Among other things, they treat all mergers within a broad industry the same for the purposes of concentration, even if a merger does not increase share in any relevant antitrust market. To be sure, any casual observer or consumer will notice that market concentration is increasing in certain sectors, and the CEA report has a level of basic intuitive appeal. Yet it takes a tremendous leap of logic to conclude that antitrust law enforcement is the cause of these particular trends. Antitrust enforcement requires the consensus to be subject to constant reevaluation and scrutiny to maintain its foothold. But a guilt by correlation approach implying a casual connection between enforcement standards and specious concentration measures does not advance this conversation. Enforcers need to be more vigilant, but they also need to be more humble. Of course, enforcers carrying out the antitrust approach, consensus approach, are not free from blame. In fact, looking back over the past 100 years, American antitrust agencies likely have made more enforcement mistakes than any of their foreign counterparts. Thanks to the Chicago School, a lot of that was redirected and corrected. Yet we still carry the mantle of leadership as the global economy encounters more challenges from digitization. That's because our evidence-based approach to antitrust means learning from our failure and continuing to take action where harm to competition arises. Despite our efforts to learn from the past, we have recently failed on repeated occasion to address the harm imposed by some anti-competitive mergers. I refer to the imposition of so-called behavioral remedies on transactions, both horizontal and vertical, that if cleared outright would substantially lessen competition. At best, the enforcement intuition behind imposing such consent decrees is to strike a compromise that might preserve the efficiencies from a merger while hoping that the merged company will not act on its natural economic incentives to harm competition. At worst, enforcers may be attracted to behavioral remedies as a convenient way of saving face when clearing politically unpopular mergers, or worse yet, as an opportunity to advance goals with only an attenuated connection to competition. All these instincts are misguided, and they fly in the face of an evidence-based approach to enforcement. Behavioral remedies for anti-competitive mergers often are prone to failure because they seek to cure on paper the enormous financial incentives that motivate profit-maximizing businesses. The empirical support on behavioral remedies demonstrate they're dubious because too often they fail to constrain the ability of merged companies to act on those incentives, and they overestimate the willingness of aggrieved parties to come forward and risk the consequences of an enforcement action. Do harmed companies want to challenge their necessary future business partners whose ongoing business relationships they need in an adversarial proceeding, such as arbitration or a decree enforcement action. One institutional change we're implementing to try to address enforcement of DOJ antitrust decrees, both past and future, is the creation of the Office of Decree Enforcement with the sole goal to ensure compliance with and enforcement of those decrees. We will provide more details in the coming weeks. American consumers deserve better than unenforceable fixes. The stakes of digital markets are enormous. That is why we're all here today. That is why Congress held hearings earlier this month in Washington, D.C., and why the Senate held them almost 20 years ago in the Microsoft hearings. If there's clear evidence of harm to competition in digital platforms, enforcers must take vigorous and timely action and seek remedies that protect American consumers so that the free markets or the consumers don't instead bear the risk of their failure. Thank you. I am happy to be courageous enough to take a few careful questions that have nothing to do with pending matters.
It's basically just on a question on what you said about revealed preferences. And would the 20 to 30% of users who choose ad blockers be potential evidence of a revealed preference in antitrust for privacy?
Exactly. I think those would be some that I mentioned as far as some of the new tools for privacy settings that they're using. There's ad blockers. There's a number of private screening that, for example, Safari and others are providing.
Yes, I just wanted to ask a particular question, but framed by the frame you used for the beginning and end of your remarks and periodically through. So I'm a big believer in evidence-based everything, and certainly evidence-based antitrust, which is dearest to my heart. But you also talk about how a case needs to have clear evidence of likely effects and things like this. And as we know with evidence-based medicine, we have millions of tumors being removed every year when there is not such clear evidence, because the evidence-based practice suggests that given the risks, given the downside, the fact that we actually have no idea what this particular tumor might be doing, all things considered, we should remove it. So the question is really how to take this juxtaposition of frequent, huge uncertainty, especially in very important areas, with a desire for evidence-based rather than do whatever the heck we want in enforcement and make them work. My particular is something that came up at both of the sessions this morning and has been on my and I think many people's minds. When we see a large established firm like Facebook, Google, but it could be in other industries, big pharma, this comes up many places, and we see them buying over time large numbers of small entrants, biotech, tech, this or that. They know a lot more than the enforcers will ever know about the future potential competitive threat of those folks. They may be buying lots of them for benign reasons. They may be buying most of them for anti-competitive reasons, knowing that most of the time it will be a waste of money because most of them wouldn't have turned out to be a threat. If we wait till they're a threat, DOJ or FTC will not let us acquire them. So we have to buy it before sort of anyone can tell. So basically we take this evidence-based demand of certainty, we operate in the background of that, and we essentially, at somewhat higher costs, can do whatever we want without any real concern. And then once we've acquired them all, we've taken out potential competitors, we're much stronger. A Section 2 case, we either don't do anything wrong or it's going to be too hard to show. So I'm giving it the contentious push one way. I have another version I'm not giving today, which is why we shouldn't go after these mergers. But I just wanted to put that up either for the particular or for the more general question about uncertainty.
Well, we certainly, we don't want to be harming. And, lots of economists have done a lot on the type 1, type 2 errors, and we want to be sure that our enforcement actions do not harm what would otherwise be either pro-competitive practices or efficiency-enhancing mergers. And that's why you need to show that a particular behavior or transaction, and that's why we bear the burden of proof. This is not the same legal system around the world, but we go to a court, the judge has to keep us honest at every level, and that's how the law has developed, the common law and antitrust. and it's been flexible enough to address the various challenges. I mean, you address some acquisitions, and I just got to remind folks, and most people know, that the Hart-Scott-Rodino laws do not limit. There's not necessarily a laches defense if one doesn't take action, but there's evidence of competitive harm, and there have been recent examples of that. You can seek divestitures. Sir.
I don't know how I got the mic without raising my hand, but somehow it worked. I wonder if we could go back in time a couple of years. The Wall Street Journal reported at one point that the FTC's internal antitrust investigation, that their internal staff had concluded in a report that Google was in fact blatantly violating certain antitrust rules, and the Wall Street Journal then leaked part of that internal report, which was quite dramatic in its findings. And that was conducted in 2012, an investigation. And I think you're aware that in January of 2013, rather suddenly and apparently without cause, that antitrust investigation was simply terminated over the recommendations of the findings of the staff. I wonder if you could comment on that. What do you think happened there?
I obviously can't comment. I was neither there nor am I privy to the evidence or the facts based. But I should say that, you have leadership that comes and goes, and a lot of times the different agencies, and at the Federal Trade Commission, you need 3 commissioners to agree to bring a case. And even at the Justice Department, Carl knows well, staff could have a recommendation memo. They'll come up, you'll have a debate, and you analyze it, look at the pros and cons, and you factor in various considerations on the case of whether or not, what kind of enforcement action you should have. So, I mean, it would be unfair for me to make any comments about that particular transaction because I'm just not privy to the investigative material.
Last, or in almost exactly 1 month, it's the 20-year anniversary of the beginning of DOJ versus Microsoft. There was an interesting article on the cover of New York Times Magazine in February by Pulitzer Prize-winning author Charles Duhigg that went through and interviewed Microsoft executives where they discussed how DOJ versus Microsoft really paralyzed the culture where product managers now had to walk down the hall to ask lawyers about minutia, and that there was this sort of counter narrative, something different than what you hear in Silicon Valley, that DOJ versus Microsoft was sort of a stalemate and it didn't really have an effect. There was this counter narrative that emerged in Duhigg's story that the trial was the remedy, and that by bringing that case, it oxygenated the markets and ironically allowed for the rise of Google, which was born actually 6 months after the trial started. Do you accept that thesis that the trial can be the remedy?
The trial itself should not be the remedy. I mean, if the premise of that question is you should bring a case just because the trial in and of itself will regulate behavior, I think that is not, as a law enforcement agency, that's not our duty, nor would that be appropriate. If you're bringing a case, you better believe you can win. And I have not brought a case I didn't think I should win.
It's great to see you again in office after a number of years. One sees in your comprehensive and bold remarks an underlying skepticism about behavioral remedies. Could one, without drawing you into inappropriately general inferences, could one imagine that this would bring a more favorable attitude to more merger challenges in the merger area? And in the case of monopolization, could this set out a perspective of less infrequent implementation of structural measures, break-up decisions?
Thank you for that question. Let me just separate, mergers where there's a different legal standard, and Section 2 monopolization type of cases, and where various remedies may be appropriate. And I've been asked, and some commentators have said that certain recent actions or speeches by me means that there's no behavioral remedies could ever work. That's not true. My view is, in very rare circumstances, only if there's not a structural remedy available that addresses and leaves to the markets to regulate prices, should they be used if they are appropriate and narrowly tailored. It's just that when there is a structural remedy available, and there's evidence for that, that's preferable to the behavioral. When you're dealing with monopolization, it could very well be that it is, it could be an appropriate remedy if you have appropriate enforcement of that. I don't know. I mean, I've asked the last 6 months now that I've been confirmed in the division, is when we have these consent decrees, and we have a massive review of our 1,300 current ones on the books, these things start having lives of their own. The music industry and the movie industry have been regulated by consent decrees for 75 years plus in this country. How do we look at them, and then how do we enforce them? So the current legal standard for proving an antitrust case, a violation, is preponderance of the evidence, 50 plus 1 approximately. And to enforce a violation of that consent decree, of those promises, it requires a clear and convincing standard that in our legal system in the United States, it's not quite the criminal standard, but it's pretty darn high. And all of our new consent decrees require the parties, whether they're structural, and one that was recent behavioral one that existed from a couple of years ago that we are continuing to enforce, all of them, and including that one that was negotiated before, have new provisions where the parties agree to just a preponderance standard for any violations. So we're going to keep those folks, their feet to the fire. If you've promised to do something to solve an anti-competitive problem, we're going to do that. And in addition, we have very limited resources at the Antitrust Division or the FTC. Most anti-competitive activity is stopped by companies being good citizens and having good counsel advising them that this stuff is bad and having the deterrent effect. But we have so many transactions, especially now, that to have the resources to continue to monitor these consent decrees is just a challenge. So we're creating this new office with a handful of attorneys just dedicated full time to make sure that the businesses are not only complying, but if there's a violation, we immediately bring enforcement actions. And I think with some of those recent changes institutionally we're doing, they can be more useful. So as far as the mergers, most mergers, I don't know what the exact number is, but over 90% don't get much scrutiny. I think it's close to, it's like 2 to 3% that ever get challenged. So most transactions get through. It's those close calls that that sometimes enforcement agencies, take a duck at. And I'm hoping that if there is an illegal transaction, that there's either an effective remedy or a challenge in court. And the previous administration did a good job. There was 5 or 6 wins in a row. Some of the insurance mergers, some dealing with waste management and all of that, and energy solutions that were challenged appropriately and succeeded in the court system. So we will continue that. Hope that answers the question.
Yeah, I have the mic, so I guess I get to ask a question. It seems like asking for more evidence is the right idea, but a relatively uncontroversial one. But my question would be why the evidence doesn't exist now. We got a lot of brilliant economists and lawyers in the room. Have they not thought of these questions yet? Or is there some other issue? Is it that the DOJ doesn't gather evidence itself enough, like looking at doing merger retrospective analysis? Or is it a question of control of the information? Do the corporations have too much control over the data and are not giving it in some way? Or is it a question that economists and lawyers for Covington and Burling or Jones Day or big law firms and economists working for universities like University of Chicago get a lot of funding from corporations and then don't have the incentive to look for this evidence? So why don't we have the evidence?
So I'm talking about specific evidence of a particular anti-competitive conduct about a particular matter. And this is not just some general aggregate evidence that I'm referring to. As far as the thinking and the analytical tools, I think there is a lot that is going on. Of course, we're here, and at other institutions like Berkeley and others, there's a lot of thinking that continues to advance our thinking and approach to these challenges. I mean, I obviously can't comment on any investigations that might be ongoing, and there have been multiple investigations, naturally, that we have opened. So getting the evidence is one thing. So you have citizens or customers or whomever may complain to the DOJ, and we'll take a look and advance that. As far as I think if your question is some of the subject of this conference, some of the big platforms, that there's all this evidence. Like I said in the speech, we are and should be open to receiving any of that type of data that is credible, and we have a duty to investigate. That's probably the extent of what I can say about any of that. So it's not a condemnation that there isn't any. It's just that is there enough to meet the burdens that we need to meet to bring an actual case.
Hi, just following up on a previous question about potential competition, and I think both question and answer reflected, how difficult that sort of thing is to approach. Maybe kind of an intermediary step would be thinking about serial, small acquirers. So, we've seen companies in multiple industries kind of make a bunch of acquisitions that fall below the HSR threshold and kind of continue to get away with it. So you might have a 40% actor that couldn't buy another 10% share, but they can buy 10 1% shares or 20 0.5% shares. Is that just going to be a perpetual loophole, or is there anything you think that can be done to address that?
No, I mean, the low HSR transaction, I mean, remember the Hart-Scott-Rodino, I forget the threshold's around $85 million, give or take a couple, is reportable, but we certainly have enforcement actions, so does the FTC, for below threshold transactions. So that is going on. And then in addition to that, we are quite active. In fact, we have a running joke that my principal deputy is very fond of Section 8 of the Clayton Act that deals with interlocking directorates, where you have either an institutional body that might control multiple competitors, and that's certainly actionable. And the DOJ, I want to say 15, 16 years ago, was actually involved in one of those cases. And if there's been a violation of the Hart-Scott-Rodino law where folks have not, have tried to evade that, I can tell you that there's at least 2 matters right now that are ongoing that we are taking enforcement action in.
I wanted to follow up on an earlier question. If you're more open to structural remedies in a monopolization case, given all that you're disfavoring of behavioral remedies.
I know. Look, if there is a structural remedy that better solves, is more effective in a monopolization case, absolutely. I'm not ruling that out. I'm just saying there might be more of those instances where a behavioral remedy for a Section 2 type of violation could be more appropriate, whereas in a merger where the parties are acquiring themselves and it wasn't organic growth, there could be many more instances where structural remedy is appropriate. But I point you to, Bill Baxter, back in the early 80s, the former head of the Antitrust Division, and the AT&T case back then, where behavioral remedies were proposed, and Bill Baxter said, no, you need to have a breakup for it to be effective, and it's a much more market-based remedy. And as he has written some there's some great law review articles from when he was at Stanford that talk about that, and also consent decree. And a lot of my views are, I'd say, informed by not only my own experiences, but experiences from a lot of predecessors and academics and others in this room. But looking back at Robert Jackson's speeches from 80 years ago, many of which are quite relevant today, and Bill Baxter's views from early 1980s, almost 35 years ago. Great.
So as the digital platforms increasingly gather data, one of the most important consequences is the increasing use of price discrimination. And so increasingly across a lot of different markets, you're seeing potentially personalized pricing choices and the breakdown of the pricing system itself. Or one could argue that there is a breakdown of the pricing system itself. How do you do evidence-based antitrust enforcement when pricing choices are held within large private institutions that keep those pricing choices opaque to the public and to public bodies?
Boy, we could teach a whole semester on just that question, can't we? You would have to take a look. Look, just the pricing decisions, and if you could have much more precise price discrimination, that is, that could be more efficient because somebody may have a different value for a different product. I could see efficiencies that could be gained and it not being illegal. Of course, we have the Robinson-Patman Act and some of that, it's murky standards that could certainly apply in an enforcement action or a private case. But I think, if you have, pricing decisions based on data that you have, unless you're colluding, it is subject to a lot less scrutiny than if it's, if there's a legitimate reason to engage in that for the benefit of the consumer. So you would have to take a look ultimately of what kind of effect it actually has on the competition itself for doing that. In some cases, it could be a lot more competitive because you might have, prices that you can lower, and certainly in the international market on pharmaceuticals, that happens now. You don't need a whole lot of necessarily data to engage in that kind of price discrimination. But if you sell a pill for $20 in the United States, but only $2 in India because that's what the economy demands, and if that was $20 in India, nobody would be able to buy it. There could be legitimate reasons for doing that. Thank you very much. Thanks, Guy. That's one I hadn't thought about.